extension of interim that is expiring on 31st August 2025. It's a civil revision application.
Give. Under the heading extension of interim. Sorry? Civil or criminal? Civil. Criminal issue.
May I have your lordship leave?
I beg your pardon?
May I have your lordship leave to mention 3 matters for extension of interim order?
Wait, madam, wait. By me?
And the order has not been compared by the response.
Give it. Why have not mentioned it earlier? This is the last week of the circuit. Contempt. আমারও তো মনে পড়ছে না। Be that as a question, see. Give me a sec. Wait, madam, wait. মামলা ফাইল যদি না আসে তাহলে তো এটা প্রিন্সিপাল বেঞ্চে যাবে না, আমারই তো কন্টেম্প। Yes. Inclusion of the list, what matter?
May I have your lordship?
Madam, wait. I'm still here. Up to 8 p.m. I'm here.
Apologize, lordship.
Give, I shall see. Yes, madam.
May I have your lordship leave to mention 3 matters criminal revision application for extension of interim order, lordship. The
All the
interim order
three
has expired, Yes, lordship.
All the 3 matters.
Yes, lordship.
When it is expiring?
Yeah, lordship, it has expired on the last circuit, lordship. I have mentioned in the last circuit, but it was not listed due to some technical errors.
Give.
Yes, lordship.
Give the slip. Who
Yes,
will
lordship.
hand over the slip? You ask এগুলো? Huh?
Your
Nobody
lordship,
is here, no on your part.
your lordship, my junior will be there. He will provide the.
Will be there, no. He or she has to be present. This way I will pick up the mentioning. Sorry. Mention tomorrow and ask your senior, junior, partner, friend, remain present or in court at the time of mention.
Okay, lordship. Much obliged, lordship.
Don't say okay. Okay is not a good term for the court.
Sorry. My apologies.
All the list. Your name. Who has courage to type a wrong name of yours? Huh? That to sitting in Jalpaiguri. What would be your correct? Rishin. It has been made Roshin. Very good. The instant matter is listed today under the head. ভোকালাত নাম্বারটা উপরে কেন গো? What is scan 1 for? Scan 1টা বার করে দিন। Who's for the appellant?
Matter pertains to principal bench, Lordship, because pending principal bench, but two instance matter appeared today, I have no knowledge. No notice has been served upon me.
Let me see. দেখি ফাইলটা কি আছে।
Already I have submitted, Lord. Not got the can one, no?
I will serve the can 1.
Sir, an instructed with sir. No, I have not.
দেখি দিন 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 দিন। Who is the advocate on record for the appellant? Then serve copy. Serve copy. Both the appellant and the respondent
Item number 3, my lord, was used to admit the appeal on 14th of August, my lords. But inadvertently, my lords, there has been, my lords, an error in the cost title of the order. Instead of, my lords, Dipti Sarkar, my lords, Dilip Sarkar has been recorded. Order dated 14th of August. Press point number 1.
The instant matter is all right. Ashur. Call the next matter. It 2 PM করা আছে না? এটাও কারেকশন নাকি?
Item 5, Lordship, there is no application for.
না, item number 4 2 PM কেন করা আছে এটা? For correction? To be mentioned is very 2 PM এ দেখে নেবো।
Item number 5, I'm bring for short password.
Not today. For extension of interim order, password is not possible. There must be a limit of it.
For the petitioner, item number 6, Lordship. This is my service, Lordship. It's a very short matter, Lordship. If your Lordship permits me, then I may place my case, my lord.
What is the matter about?
But for 2 reasons, I filed one application under section 482 of the Code of Criminal Procedure. I am
Yes.
an accused person under section 138 of the Negotiable Instrument Act before the learned additional ACJM Kashian.
You are the complainant?
No, I am the accused person there.
Yes.
So I received the wrongful summons from the court lordship
Hmm.
with very much hardship. Somehow I have find out the appropriate court and I appeared. This is my summons lordship that I have received from the court.
দেখি ওগুলো কি দিচ্ছেন?
The case was pending. This is the original copy, Lordship. The case was pending before the learned additional chief judicial magistrate Karsian But I received the summons in the heading of ACJM Siliguri Lordship. Kindly see the first page of the summons, Lordship. At the first page, very first page. I have annexed it and I have handed over the original one, Lordship. There is a correction. There is a pen through at the date portion also, Lordship, at the bottom of that page, Lordship. Firstly, it's written as ACJM Siliguri. Though the
The heading
yes, Lordship, at the heading. Kindly see the heading.
in the court of the learned additional judicial magistrate at court at Siliguri.
Siliguri. Kindly come.
Who has signed it? ACJM Karsi.
SCM Karshian Lordship. This is the first thing. Secondly, Lordship, kindly see you are hereby required to appear in person before the learned judicial magistrate court at Karshiang. There is a correction on the date also, Lordship. This is the first thing I am showing it to you.
Then
Then, Lordship, somehow I managed to appear before that specific court, Lordship.
which court? Siliguri or
No,
Karsi?
that is pending at Karshiang. SCM Karshiang. Learned SCM Karshiang, I appeared, Lordship, and I surrendered and I was released on bail. Subsequently, Lordship, I filed one application under Section 45 of Indian Evidence Act stating that the contents of that check, the handwriting was not mine. That application is kept pending, though there is nothing, no record in the order sheet, Lordship. This is the second thing. And keeping that application pending, evidence has been started. Now, on 17/9/2024, the day.
What is your application to that effect? Have you annexed?
Yes, Lordship, I have annexed that P4, Lordship.
Page number, sir?
Of my main application, it's 22. Of my main application, Lordship. It's kept pending there, Lordship.
Let me read, sir.
Lordship. 22. Main application at 22. P4.
You have been forced to put your
Lordship.
signature on 3rd January.
Lordship.
And your husband lodged an FIR on 21st February.
Lordship.
Very good. Then what happened, sir?
Then, Lordship.
When it was filed,
Which one, my lord?
this application?
This application for Section 45 application.
Yes.
The very next date I appeared before that court, that was filed, Lordship.
What is the pleading to that effect? In the application for quashing, what is the pleading to that effect?
I'm bringing it to you, Lordship. I have mentioned it my application, Lordship, at page number 3, paragraph number. Page number 4, Lordship. It's starting from page number 4, paragraph number 8, Lordship. Of my main application. From paragraph number 8, it's starting.
In paragraph number 8, why it is written that it has been filed on which day?
Date has not specifically been mentioned here.
Very good. Then what happened?
Then, Lordship, another date was fixed on 17th September 2024. On that day, there was Vishwakarma Puja and one Shraddha on my residence, Lordship. So I could not appear before that court. Now, due to my absence, a non-bailable warrant was issued against me, Lordship, though the case is bailable.
If you
I-
do not appear, what will be? The
Lordship,
court will wait for you.
no, certainly not, Lordship. I sent one advocate. His appearance was not been recorded, Lordship. That's not recorded in the order sheet also. How
is absent and without stay. This is the order.
that was the order. However, Lordship, whether I was filed or not, that can be ascertained from the court fee register of that court also, Lordship, because I filed one application, Lordship. Now on my
On which day?
on 17th September 2024. I was absent on that day. There was page 25, Lordship. This is the order.
Yes.
Now, Lordship, I tried to appear before that court and prayed for. I filed one put-up application to surrender again, and that application was not heard, Lordship. I have also filed the copy of that petition also. Kindly come to page number 30 of my application. Now, finding no other alternative, I approached before this court for two prayer, Lordship, with two prayers.
Page number 30.
30.
Hmm.
I clearly stated that I was not a willful bail jumper.
So,
But
on this application, what order has been passed?
no order has been passed, Lordship. Now, Lordship, I filed this petition before this honorable court, and Honorable Justice Shubhendu Samanto stayed all the proceedings and also stayed my warrant of arrest, Lordship.
Which is under challenge.
My lord, I have come here for two reasons. Firstly, my warrant be stayed, Lordship, that has been done, and secondly, I prayed for transfer of the proceedings because the entire series of the facts shows that I have not been impartially treated before that learned court, Lordship. And kindly say once again, Lordship, my summons. On the summons also, the petition is not annexed. There is no annexure has been tagged with the application, Lordship. That has been handed over to me. Kindly see that, Lordship. My original summons that I have handed over. MD Ruknuddin SEJM Koshiyang. Therefore, Lordship, I have
Now, one new officer has joined, everything will be ordered. Take it off.
So at first, he can process it. There is no class.
She has to dispose of
Yes.
the learned trial court. But there must be a reflection to that of him.
I have
In
submitted.
the events an application is filed, there must be a reflection to that effect in the order sheet.
Defective summon was served upon me, Lordship. May I get back my summon? Lordship, that's true. May I get back my summons, Lordship? এগুলো সে টাকা দেয়? MD Ruknuddin. MD Ruknuddin.
Company na.
The record, Lordship, this contact was not at all, Lordship, at the court also, Lordship. Lordship, that's true, Lordship. And when the case is under section 138 of the NI Act, I don't want to say what are the consequences over there, Lordship. Lordship. Grateful, Lordship. Grateful.
Sir, I am appealing for the state.
Lord, in 7, I am for the petitioners. And Lord, 8, I am opposing the application. Yes. Yes.
Lord, 7, I am opposing, and for 8, Lord, I am for the petition. And both the matter, Lord, I am appealing for the state. Oh, my.
No, my
No,
lord.
my lord.
Same my lord, quashing applications, same day's incident, my lord, case and counter case. Yes.
অন্য ম্যাটার না ওই ইয়েটা কোথায় কালকে যে প্রিন্ট করতে বললাম স্টেটের ওই 7 and 8 বলছে হ্যাঁ ঠিক আছে এক কপি কেন 2 কপি বের করলে ঠিক আছে
Yes, who's part of the petitioner in 373?
I am for the petition. In
That's
370.
for question.
My lord, my lord, if my lord is hearing out the matter, are hearing out the matters, my lord, in the second application, I have not yet been granted an opportunity to oppose that application. My lord. I have not filed my affidavit in opposition.
even in the first application my lord in this I have not filed any opposition even opposition is not required
373 is the issue.
ও আচ্ছা আচ্ছা Lord, opposition in such cases, my lord, this if we move forward, if your lordship hears the matter, lordship will find that
My lord, I
there is
have
no
no
requirement.
difficulty in hearing out the matter, my lord. I am only praying for a short liberty, my lord. Let me oppose that application because
You oppose
it is
it.
arising. My lord,
The
their
item number
application
8.
CRR 291. CRR 291, item number
Item
8.
number 4. Item number 8.
Yes,
Now,
I shall. No. So, my lord, yes,
So that's your case.
my lord takes up the complaint. The complaint is at page 18, my lord.
page কত বলো 18
The number?
Page 18 is the FIR, my lord. Written complaint 19. 19 is the written complaint.
Yes.
So, my lord, the FIR states, I, Ashna Sunam, scheduled caste, daughter of such and such, resident of such and such, would like to lodge a written complaint
but I am for this too both
to the following effects. It says,
yes
my lord, my grandfather, late Krishna Bahadur Sunam, my elder sister Trishna Sunam, and my mother Hira Devi Sunam are the actual owners of a land measuring 1.69 acre, land measuring 41 decimals recorded in Khatiyan number such and such, land measuring 1 acre recorded in Khatiyan number such and such, land measuring 28 decimals recorded in Khatiyan number 21 of Moja, Panchkolguri, which is in our possession since the death of my grandfather. So, my lord, apparently this dispute has arisen out of a property. Now, Lord 2 says, 2 is where the crux of the complaint starts from. That for the last 1 year, said Dhiraj Ghosh, son of late Dhirendranath Ghosh, resident of Goshaipur, POPS Bagdogra, and his associates goons were forcefully trying to encroach our aforesaid land, but somehow we managed to protect our land from the hands of the said Dhiraj Ghosh. 3 says that today at around 11:51 a.m., the said Dhiraj Ghosh sent his associates goons, namely, then it names the petitioners, my lord, I am for A to G. A to G except F. A, B, C, D, E, and G. Send the following persons, along with more than 300 people, entered our said land forcefully and encroached our aforesaid land in absence of my father and brother. And when I, along with my mother and also with my other family members and well-wishers, raised protest against their illegal activity, at that time, they became furious and started assaulting me as well as my mother physically with kick, fist, lathi, rod on my mother's body, and also threatened us with sharp weapons like dao, khanti, khukri for dire consequences. Not even that, Dhiraj Ghosh's associates goons tore my mother's clothes, challenging and outraging my mother's modesty, and also used abusive and discriminatory language upon us and told my mother and me, तेरे जैसा नीचा जात को 2 minute में उठा दूंगा, and also spat on my mother's face. This is, my lord, the crux of the complaint. Now, my lord, firstly, the charge sheet has been filed in this case. So, my lord, firstly, the petitioners before your lordship are also members of the scheduled caste. That is my first submission. So, my lord, in the charge sheet, yes, my lord, the petitioners are scheduled caste. All, my lord. E and G. E and G. Only F and, my lord, H are, my lord, general. My lord, I'll place the chart sheet, my lord. The chart sheet takes up, my lord, page. The charge has been dropped. Yes. The charge has been dropped. But SC/ST Act. But I say, my lord, that the charge under the SC/ST Act has to be dropped in totality. I'll show that to your lordship. Because the allegation that has been made in the FIR, because your lordship is exercising 482. In 482, my lord, your lordship has to see. No, only the petitioners, but I am pressing that the charge has to be dropped in totality. That is not required, my lord. Even a third person can agitate a section 482 application. Your lordship can exercise this jurisdiction aggrieved by the charge sheet. No, my lord, they are general, but the offense does not lie against them, because the offense has, my lord, 3 ingredients. Firstly, the offense has to be on the basis of the person, the victim belonging to a scheduled caste. That is number 1. The complaint has to mention 2 things. Yes. The sections leveled are 31R and S. R is, my lord, humiliation, and S is, my lord, abuse. Yes. Yes, that is R, and S, my lord, is abuse. Yes, these are the two sections leveled against the. S is also not attracted, neither is R. Not because, firstly, it has to be with the caste name. My lord will see S. My lord will see 31RS, 31S. It says that the abuse has to be with the caste name. Let's say I call a person of the scheduled caste, if I may use that word, my lord. Let's say I call a person Chamar, or I call a person with that name of his caste. In this, the allegation is tere jaisa nicha jaat ko utha dunga. This does not fall within the purview of.
it's not attracted.
Also not attracted. Because, my lord, it has to be on the basis of that person belonging to a scheduled caste. My lord, the intention of the legislature is to curb caste-based offences, not general, my lord, passing comments made on any person. This is a passing comment which has been alleged. Passing comment, there was an altercation. In an altercation, he said, "Tere jaisa nicha jaat ko utha dunga." That is all that he said in the complaint. This cannot be within the purview, my lord. I'll show your lordship the judgments. Because the intention of the legislature is to curb, because, my lord, there is a Supreme Court judgment in Hitesh Verma, completely identical to my case, Hitesh Verma as well as Godish Penthia. These two judgments I'll place before your lordship. In those situations too, similar comments were made. Similar comments were made. The Supreme Court says that this is a passing comment. This cannot come under the purview of the SC/ST Act. You cannot call that an humiliation on the basis of the victim belonging to a scheduled caste. It may be a humiliation. It may be a passing comment made. But, my lord, I'm arguing for all of them. My lord, that is not required. I'll show that to your lordship too. Any third party can invoke a 482 jurisdiction. My lord, that is on the sections under the SC/ST Act. SC/ST Act, according to me, does not stand at all. Yes, ma'am. Charge sheet says that against the F and H. What not before your lordship. That is one, my lord. Yes, my lord. Charge sheet starts from page 21. Page 21. My lord, page 22 is relevant. Page 22, my lord, the second last paragraph onwards are the brief facts of the case. It states the fact. I'll read out from, my lord, during investigation. During investigation, a prima facie charge has been well established under section 31 RS of the SC/ST against accused Mithu Ghosh, son of late Devobroto Ghosh, and, my lord, Saurabh Chando, son of Sharad Chando of Timolpara district Darjeeling. Now, my lord, kindly turns to the complaint once. Complaint, my lord, kindly sees the names F and H. F is Mithu Bishwas. F is, my lord, Mithu Bishwas. H is, my lord, Saurabh Ghosh. Now, my lord, Mithu Bishwas has been named as Mithu Ghosh, completely different person altogether. Kindly sees, my lord, Mithu Bishwas, resident of Matigara. He has been named as Mithu Ghosh, son of late Devobroto Ghosh. A completely different person has been arraigned as an accused. Same goes for, my lord, Saurabh Ghosh. Saurabh Ghosh, my lord, son of Dhiraj Ghosh, mentioned in the complaint, number H. And, my lord, he has been named as Saurabh Chando, son of Sharad Chando. Where from these persons have come, my lord, I do not know. Mithu Ghosh. Ghosh has been described as Saurabh Chando. And Saurabh Ghosh has got another particular in the complaint, which is son of Dhiraj Ghosh. But, my lord, we'll see the chart sheet. Saurabh Chando is son of Sharad Chando. That is the first infirmity. So, my lord, as against Mithu Bishwas and Saurabh Ghosh, there are no charges under, my lord, the SC/ST Act, because the chart sheet itself says that. Chart sheet arraigns a completely different persons as accused. Now, my lord, next, it says it was further revealed that all other 6 FIR named accused persons, then it names the petitioners before your lordship. They have submitted their SC certificates, and as such, 31 RS will not lie against them. But 323, 354B, and 334, my lord, kindly turns to page 23. I'll read out from the paragraph accordingly in compliance, my lord. The first are the enumerations of the caste certificates. Yes, my lord. So accordingly, in compliance with the kind instruction of my superior, submitted Matigara PS chart sheet under 31 RS, read with 323, 354, 34. 354B and 34. Against whom? That is again another question that I put to myself, my lord. Now, my lord, this chart sheet is completely against the dictum of the Honorable Supreme Court in Sharif Ahmad. Against, I do not know, my lord, because takes up, my lord, page 22. 22, my lord, last line. 22, my lord, last line. It says R belongs to SC ST and having caste certificate duly verified. After that, my lord, my chart sheet does not. I have received the chart sheet, my lord. It is as illegible in my copy as it is in your lordship's copy. My lord, will kindly see the case diary. ওই brief facts of the case জায়গাটা দেখো।
Next page. First page of the chapter.
Yes, my lord. Yes, that is perhaps what it says. But after that, he submits the chart sheet consolidating. Yes, my lord. আবার কি আছে?
I will present. I want to see the chart sheet.
You will not come under the foreign norms, sir. Yes.
But there are other sections of IPC as well, my lord. So basically, the crux and essence of the charge sheet is that so far as this petition is.
In terms of the chart sheet will be very
My lord.
Yes.
clear.
যেভাবে লেখা
Understand.
যেভাবে লেখা আছে ঠিক আছে দেখুন না লেখা কি লেখা আছে এই দেখুন ওরা আসলো না এই ফাইলগুলোর মধ্যে আসলো না হয়ে গেছে তারপরে সুপিরিয়রের পরামর্শ স্টেপ তো আইপিসি দিল এক্সপ্লেন করতে হবে লেট হিম এক্সপ্লেন তারপরে কতটা আমরা দিন আমাদের
Because which section has been given in the chart sheet?
Not clear at all.
Why is the original chart sheet has been submitted?
Original chart is submitted in the trial court, my lord. This is the Xerox copy. Office copy, my lord. From the IO scope. My lord. Page 121, 120, ভুল হতে পারে ম্যারেজে কি সেকশন দিয়েছে ওটাই জানতে সব ফুল ক্লিয়ারলি লেখে পেজিং পেজ 18, 19, 20, 21 হ্যাঁ হ্যাঁ হচ্ছে মালার ইয়েস মালার দিস ইজ দি একটু এটা একটু প্রপারলি অ্যারেঞ্জ এখানে স্পেসিফিক বলা আছে পেজ 120 is the relevant portion মালার 120 mark as 120
Teacher one.
না না সিরিজ এখানে স্পেসিফিক করা আছে এখানে এসসি এসটি আর এই যে এখানে করা আছে
So no charge sheet was submitted under
SC ST Act against these petitioners. Again, no charge sheet submitted under section SC ST Act against these petitioners. Only 323, 354B and 506/34 of IPC.
against whom
Saurabh Chando and Mithu Ghosh, they are belongs to general. So SC ST Act lies upon the
But they are not
and-
named in the FIR.
And they are not, my lord, petitioner before your lordships.
Also not named in the FIR. my lord.
But they are named in the FIR.
No, they are not. That one-
Ghosh or Vishwas, that will I will explain.
My lord, takes up page 22 of my application. My lord, the first page of the charge sheet, that First page, my lord. Brief facts of the case, my lord, that paragraph, last line. Last 3 lines.
but those Saurabh and Mithu are not before this court.
No,
Not before your lordship, not named in the FIR, nowhere, nowhere to be seen, my lord. Why?
no,
My lord, if your lordship grants me that liberty, I'll find an
no, what,
application.
why? Lord,
That I may, my lord. But my lord, even otherwise, under 482, my lord will see whether 482 has been initiated before your lordship. First, if in a 482 application, my lord sees. Yes,
And if no material is
found against them.
then time of trial, they will get the benefit of doubt.
No, my lord, I am on the charge sheet itself. If no materials are found against them, and if the materials found against them do not stand the charge, because my lord will have to see the FIR and the materials collected as per Bhajan Lal. Yes, my lord. That is what I'm coming to, my lord. let me, my lord. There is a 164 statement record. I was coming to that. My lord, I had occasion to produce the 164 statement from the London trial court. So, my lord, in the 164 statement, what
in the case diary, my lord, I have already handed over the case diary, my lord, but my lord, written in Nepali language. So I am
Yes, that is in
I am
Nepali.
hand up the Bengali version of the.
So, my lord, this 164 statement was recorded of the complainant. Now, the complainant states, with regard to 354, she makes an omnibus allegation that 300 people tore her mother's sari. That is the first informal meeting. 354 cannot be leveled against anyone on the basis of vague and omnibus allegations. This is not at all believable that 300 people came to the property and tore off her mother's sari. That is the first determination that your lordship has to see. Second, as regards this, my lord, Dara, as regards the offence under the SC/ST Act, she says that one Saurabh Ghosh said that tere jaisa nicha jaat ko utha dunga in the 164 statement. But Saurabh Ghosh is neither the accused nor before your lordship. The charge sheet has been filed against one Saurabh Chando.
না না ওটাকে শুধু সৌরভ চন্দ্র ও ভুল করছে বাট ইয়ে দিয়েছিল বাট আমি
My lord, after investigation, we came to learn that the FIR name title of the Saurabh and the another person, Michu, title are wrongly written. Subsequently, we have issued 41 a notice upon the actual. Yes, ma'am. Yes, ma'am.
কি আছে
দিয়ে 41 দেওয়া হয়েছে, সঠিক পার্সেন্টকে দেওয়া হয়েছে, কমপ্লাই করেছে, তাদের এগেইনস্টে চার্জশিট দেওয়া হয়েছে।
আর 164 এর কারণ না
সবাই বলে দাও তারপরে
সৌরভ ঘোষই আছে এখানে। ট্রাইবেল না, কাস্ট মনে হয়, এসসি মনে হয়।
ট্রাইবেল না, সুনাম ট্রাইবেল তো
এসসি।
I will kindly see the 164 statement of Ashna Sunam.
কারটা বলছো?
Ashna Sunam. Complaint.
বন্ড ফিজ হবে খুব ভালো কাজটা ওপেন স্পেস আছে
Anything more?
Yes, my lord.
Yes.
May I please the law, my lord?
Yes.
Yes. Now, the third section that has been leveled is 323. 323, which is hurt. Now, my lord, as regards hurt, there is an injury report in the record which says body ache. Well, firstly, she says that 300 people tore off her mother's sari. Yes, my lord, because the Supreme Court has decided. I'll place the judgments, my lord. I will place the judgments. A conclusive finding and cause the charge sheet. Yes, my lord. Because, my lord, Bhajan Lal has many criteria. Bhajan Lal says that if the allegations made are so improbable and so unbelievable then then the court exercising jurisdiction under 482 will my lord step in. Because my lord, 300 people tore off her mother's sari. There is no specific overt act attributed to anyone. 300 people. No specific overt act attributed to anyone, my lord. As regards 354. 323, my lord, same. There is no specific overt act attributed to anyone. There is an injury report which says body ache. I say, my lord, this proceeding can only run under 323. The sections under the SC/ST Act and 354 has to be, my lord, deleted from this proceeding. This proceeding can only run under 323. My lord, the SC/ST Act 31 RS and my lord 354. Both these sections have to be deleted from this proceeding. It can run under 323 because she says that there was my lord a scuffle on 14th of December, and my lord, if I may get 10 more minutes, just 10 more. Yes, sir. Now, my lord, the background of this case. The background is that this Dhiraj Ghosh, who has been named in the complaint but not named in the FIR. My lord. My lord, I do not.
Even the court find that
Yes.
the application is false,
Yes.
probably you will understand the fate. So reasonable restraint is required.
Yes, my lord. Well,
I'm not saying.
So, my lord, this entire issue has a civil dispute. My lord will kindly take up. My lord, the charges under SC/ST Act have. My lord, kindly grants me 10 minutes, my lord. Let me, my lord, place the law, my lord. My lord, there is a case and counter. My lord, this needs, my lord, needs, my lord, my lord. My lord, takes it up tomorrow.
No, but
Takes it up
my
tomorrow.
lord, after hearing,
Rejecting this application right now.
My lord, kindly grants me 10 more minutes, my lord.
my lord, nothing more to submit, my lord, since. My lord, in that matter, my lord, I am the accused, my lord, because this is the first complaint I have made. My lord, first I'll just set the background. My lord, this is the complaint which. This is
Yes,
the
my lord,
first.
same.
Arey Baba, wait.
No, no,
This is the
My
complaint.
lord, same. Yes, yes.
My lord, this is the complaint I have made. First complaint. My lord, after this, in retaliation, my lord, they have filed a complaint against my parents. That is, my lord, item number 8. Yes, it has been submitted.
Yes.
But my lord,
My lord, the
this case,
actual
my lord-
incident, my lord, if I may please.
Abar, actual.
What is the written complaint?
My lord, written complaint is exactly similar to what I have filed.
Page
Page
19.
না না এটা তো ইয়ে
Oh. Sorry, sir. ওটা তো আগের ছিল।
হ্যাঁ Lord, lordship will Lord, there is a certified 26 also there. Yes. Lord, exactly similar. If lordship will see the FIR, exactly similar.
But unfortunately, my lord, in this case, my lord, charge sheet submitted without SC/ST Act. And initiation was also without SC/ST Act, and subsequently charge sheet submitted also
In spite of the complainant
without
being,
SC/ST Act.
in spite of the complainant
Ah,
being an
because I belong to scheduled caste category. কি unfortunate.
আরে হবে তাও দেখো
I belong to scheduled caste category. My lord, my parents, my father and mother, Gautam Sunam and কি নাম? হীরা দেবী সুনাম।
সিনহা
গৌতম সুনাম and হীরা দেবী সুনাম।
আরে ব্র্যাকেটে সিনহা আছে।
হ্যাঁ তো
সিনহা তো চেনা যেতে
But উল্টো পাল্টা বলে this is obnoxious submission. পিছনে আইও আছে জিজ্ঞেস করো।
উনি আইও নাই গেছে। Don't cross your limit, Mr. Chaudhary.
তো why you
No.
Yes.
But,
Lord,
sorry,
without
my lord, I am my lord, I do not do the matter, my lord. I will hand up this matter to the Mr. Lord Deputy, my lord. He will apprise your lordship.
Why?
No, my lord. In item 9, my lord. Sorry, 8, my lord.
Why?
No, my lord.
Milord, I say I am scheduled caste. Milord, he is saying I am not.
No, Lord, I will.
That is the thing. Now, Milord, after my complaint was filed, Lord, they filed this counter complaint. Lord, registered just one after. Lord, my complaint is 1025 and this registered as 1028. Exactly similar in nature. Milord, they file it against my father and mother. Milord, my father is Milord 68, 69 years old who needs a person, Milord, support even to walk. Milord, who walks with a walker, he was not present in the spot. My mother was there, I was there. Milord, the entire incident, Milord, the entire
Page 7 is the 161 statement. Only page 7.
Milord, the entire incident was Milord was under CCTV footage, covered by a CCTV. Milord, it was recorded in CCTV footage. Milord, there are telephone recordings which I am holding, Milord, in this pen drive. Milord, these footages were given to the investigating officers. Entire footage, Milord, I have personally perused the CCTV footage, which actually and indeed, Milord, clarifies that there were, if not 300, there were almost 200 people. Milord, that is there in the footage itself, but those footages were not collected by the investigating officer, despite of giving it to them. Milord, I have done that. I have done that. Milord, my Naraji petition is pending in the trial court, but since there was a stay,
Here is there nothing CST Act, sir.
My lord.
Then
My lord, only one. My lord, my lord, only 161 statement is there, my lord. Total charge sheeted witness, my lord, I only 4, my lord. My lord, I think, my lord, Mr. Sinha will be the general, belong to the general caste.
Milord, the IO has verified my caste certificate. IO has verified my caste certificate.
That is why, my lord.
Sunam is the Milord, my title. My caste certificate has been verified by the investigating officer and thereafter the charge sheet has been filed.
Milord, let the charges under SCST Act be dropped, Milord, at least. They have been dropped in the charge sheet, Milord. Let it be quashed as against the petitioners with respect to, Milord, the SCST Act, Milord. And Milord, SCST, Milord, may I just place the law, Milord? Just 10 minutes, Milord.
Here are 370. Mr. Chok.
Melody.
Ask that to learn the facts. Give way to start the law. And thereafter, we have to go to the reported.
Right.
If we go in a reverse direction, it will be a mess.
First report.
In order to write an order, even in order to draft a petition, marshalling of facts,
That's true, that's true.
Every factor is totally different, my lord. Factor is, every case is totally different, my lord.
this sequence,
Lordship.
then you can put that.
Yes, lordship. Whereas factor is totally different. They are citing ruling and that factor does not mismatch. Lordship.
Yes, all the reasons.
Mentioned, yes, sir. But later on, I have came and saw that
Mr. Chakraborty.
copy of the main petition has not been served upon the state. Therefore, I'm praying for apology and.
Subject to payment of cost of rupees 1 lakh. Why you have mentioned? Why you have mentioned? Why you have not served?
Placed in my brief that therefore I. You have inadvertently mistaken that the matter is that the copy has been served. But afterwards, when I matched the CRM number, I understand that the main petition has not been served.
Service has been effected upon the opposite party number 2. Then I will vacate this stay order.
And
No, sir. No, madam.
this petition is against the judgment passed by the appellate in appeal, passed by session judge Darjeeling. Lordship, for setting aside this petition is for setting aside the judgment dated 9th of September 2024. This is not for watching, that's why if the stay order is vacated, then I will picturize lordship. I need consider for.
Your client will be taken into custody. By the appellate court affirm the judgment of conviction. Naturally, let him face that. You obtain the stay order and you have not served copy. Let him face. Your appeal was dismissed and the judgment and order of conviction was set aside. You preferred a divisional application, madam. You obtained a stay. Court directed you to serve notice. You didn't serve notice. You are enjoying the stay order. You serve notice, in the meantime, let the stay be vacated and I will direct the learned trial court to take your client into custody. Just see, it is in the month of November 2024 and we are now in the month of August.
Darjeeling is a rural area, therefore they have lost the connection on the client.
I'm making arrangement for the connection. I am making arrangement for establishment of the connection. At the time of hearing, what's your good Mr. Bhowik.
The ability of service. Revision was admitted and the stay was allowed. Same matter because your lordship was placed to hard on the established. Without assigning any reason, without any application on the 143A of NIS, and without making any reason in the order, arbitrarily the land transfer was placed to ask, pay 10,000 in default of the.
Where is the track report, sir? Service is not complete. No, sir.
There is the delivered tick, and the delivered column, there was a tick. Item delivered. Nowadays, madam, so for the upgradation of the software is concerned, the track report to some extent changed. The postal service.
By which order rupees 10,000 was directed to be paid?
21st March 25.
Prior to that, there was no order. Sure.
4 to 2025. Well, I have been enlarged on bail.
Negotiable instrument একটা দাও আসুন CRR 391 on 2025
11 are parties are same, situations are same.
Lawyer is same, judge is same. Date same. সিআর নাম্বারটা পাল্টে যাবে আর সিআর নাম্বার পাল্টে যাবে আর সব লয়ার নাম ঠিক থাকবে। সার্ভিস এফেক্টেড, which order is impugned? এটা হচ্ছে impugned order, খালি সিআর কেস নাম্বার 311 হয়ে যাবে আর ওই 19(4) ওটাই দিয়ে দিবেন। আর রিটার্নেবল ডেট 23/5,
21/3/2025.
রিটার্নেবল ডেট অফ ইয়ার এক্সিকিউট ইয়ার অফ, ওটা কবে বলেছি বলো? 23/5 বলেছি। সেম সেম সেম। অ্যামাউন্টটাও তো সেমই বললেন, 10th, সব সেম বলছি।
But sometimes it is partly by third court, partly by fourth court. But the determination, yes, yes.
But this scenario is that your lord has examination to.
Yes, in this circuit, your lordship has a determination to exercise.
You have realized that they are not one. I know it was very beginning.
Very excuse for my unintentional mistake.
It is right of me.
Well,
Sir, we work in the serious man is not good, Mr. Bhupi. I should not.
জামনালা লাগবে না, ইয়ে দেবে ওম প্রকাশ সানি আর প্রিন্সিপাল সানি।
ঠিক আছে তুই কি ডিফেক্ট নাকি?
না না, এটা তো এপিপি সাগনিক ছিল, আমাকে দিয়েছে করতে।
এই তুই কি করে হবে তাহলে?
এনসি সাগনিক এটা আগের ক্র্যান 1, এটা ক্র্যান 2, ওটা ডিসপোজ। ক্র্যান 1টা ইয়ে ছিল লিমিটেশন সেকশন 5।
তাহলে এটা করে দে, এটা তো আমাদের আছে।
এটা আমাকে এটা ডিসপোজ দাদা।
আমি নিয়ে নিলাম এটা।
এটা সাগনিক দেখো, তোমার ব্রিফ তোমার কাছে আছে, সাগনিক দেখো।
আচ্ছা আমি বিল করবো তোদের।
তুমি
আগে স্লিপ মার দে না।
I could not, yes. Oh, yes, yes, yes. Yes, yes. Milord is taking out read matters there. Milord. Yes.
comment, who is commenting on like some cases.
না না এটা আমার কোর্টের অ্যাপয়েন্টমেন্ট আছে।
আচ্ছা আচ্ছা
বুঝলে? হুম।
আচ্ছা
না না এটা আমি লড়বো। দেখে দেখি আর দেখো দেখাবো তো দেখতে না না সিআর এর কথা নিলাম पहले वाला कोर्ट का कोर्ट जो कोर्ट का अपन
কপি লাগিয়েছে লাগায়নি
or it's an unassisted fail. Yes, 8 and 4. 8 also? Yes, 8 for 4 year.
সাসপেনশন এখানে অর্ডার আছে দেখি এখানে অর্ডার আছে সাসপেনশন মিস্টার চক্রবর্তী এই তো সাসপেনশন পিটিশন দিয়েছে কপি টু বি সার্ভ কপি সার্ভ করে দিয়েছে আমাদের ঠিক আছে কোর্টের অর্ডার কিছু করার নেই এবিপি এখন কোর্টের উপরে গেলে মুশকিল ইনচার্জ
তুমি দাও না তোমার নাম দাও।
দাঁড়াবো এটা আমার নাম দেয় আমার সাথে কে ছিল তো
Krishna Shagnik.
আমার আর শাক নিয়ে নাম
নাও করবে
বল কোর্টের অর্ডার আছে নির্বাচন করতে দেন এগুলো লাগবে না এগুলো নিয়ে যাবে এটা কি আমার কাছে
এটা দিয়ে দাও।
brief তো আছে না ধরলে হবে না অনেক ছাড়ছি বল দেন কোর্টকে অর্ডার করুন এটা লাগবে না কোথায় আছে সামনে না তাহলে ওর নাম কেমন নাম করবে অরিজিনাল নাম করবে অরিজিনাল নাম করবে দিয়ে দাও। মেয়েরা আমার নাম অরিজিনাল নাম দিয়ে দাও না আসলে তো অনলাইন থাকতে হবে কমসে কম কোথায় আছে কলকাতায় পড়ে থাকতে পারে ফাজিলেদের দোকান কিছু পড়ে থাকতে পারে কিছু তো তাই হুম
But conviction
Yes.
for 4 years for section 8 and for 3 years for section 12. Appellant was on bail using this is suspension of sentence. Now was on bail.
তোর হাতে লেখা না
The order of the malady.
তাহলে বলে দিচ্ছি
Bail order. I am also on bail. My fees and my other bail.
Well, I filed an application. Dreaming trial, but order copy of the bill, I was on bail.
Absent was
I filed an application for CRAN 2. If you don't take the CRAN 2, it's my application for suspension of sentence.
বল তুই বল কোনো অসুবিধা নেই
সেই তো একই ব্যাপার।
ব্যাপারটা কি না
করো না, তুমি দাঁড়ালে যখন আমার
হ্যাঁ পাশে আছি
No, same. I was on bail, my lord, during course of I.
state. Oh, victim has to be served. Lord, victim has to be served. This is a POXO act.
সার্ভিস হয়েছে
If your lordship takes up the order, consecutive order, my lord, I have served, evidence have been kept on record,
Oh.
and last occasion, there is a direction upon the state also, my lord. They given.
State is requested to effect service on the private respondent.
Yes,
And submit report. Where is that report?
My lord, then I have to take instructions on that, whether that has been done or not. Let it be, আজকে তো মঙ্গল সোমবার না মঙ্গলবার।
আজকে
My lord, let it be taken out Thursday, my lord. By then, if not done service, my lord, I will try to effect service by then.
You have to.
Yes, I'll do that. বলো না।
Can one of the can one of can two.
No, can one section 5?
সাকনিক তার নাম দিয়ে দেখ না, কি অসুবিধা?
দিয়ে দাও তিনজনের নাম দিয়ে দাও পুরো সার্কিটের প্যানেলটা দিয়ে দিবি দিয়ে দাও
আরে ভাই, ও আছে তো মামলা, ওর নাম কেন কালকে তোমার ভাই? সে তো বিল না করলো নামটা।
On basis of the order, N7 verified as passed by coordinate legal scope. It reveals
এই আগে সাগনিকের নাম দেবে
that
আগে
ঠিক
সাগনিক
আছে, ওটা কথা।
the direction.
ওটা কোনো বড় ব্যাপার না।
সিনিয়র তো সাগনিক
ঠিক আছে, ওইটা বইয়ের মধ্যে কিছু আছে।
যেটা ডেকোরাম মেনটেন করতে হবে
Submit the say report is not made legal
Thursday হচ্ছে 21 তারিখ।
21st
মানে
Dr. Chaudhary. And to submit.
এ অমিত বাত করো তো
Upon the upon private reported on the.
মানে
ওটার মধ্যে লিখে দে কজ লিস্টের মধ্যে নোট করে দে সুবিধা এটা আমার
Number 13.
Krishna Mittal. This matter has to be then I think in this circuit, my lord. Already 3 days there was hearing, so already. I think one of the parties will be asking for time will want to drag it, but.
My lord, there is.
already 1:15 now. If Milord will continue this up post lunch.
My lord, if it can be taken up tomorrow, first item, my lord. My lord, kindly considers this. I'm not seeking adjournment, my lord, but I would have to place. I'm not.
আমার অসুবিধা
Dr. Chaudhary has concluded. Now we can. The last occasion, for 188 was placed.
It was being placed, my lord.
Single, I believe, you have.
No, my lord. Actually, the other matter have even not even begin, my lord. The 340 application. I have just started in this, my lord. And this judgment also, my lord, I have not taken, my lord, to the entire facts, my lord. My lord, though that my lord was considering, my lord, 1961. My lord had sought for a question, so my lord had taken my lord to a particular paragraph to answer that query of the court, my lord. My lords, kindly take para number 11, my lord, of the judgment. Eleven. No. Well, just 11. My lord, in 11, my lord, kindly see. Evidence has been classified by text writers into 3 categories, my lord, in the middle portion. My lord has found that. My lord, thereafter, that is one third, my lord had stated, I had stated that material evidence. This particular document was a material evidence. Now, my lord, we have already indicated that we are in an agreement with the full court decision of Sarma's case, that the prohibition in clause 3 of Article 20 covers not only oral testimony given by the person accused of an offense, but also written statements which may have been bearing on the controversy with reference to the charge against him. The accused may have documentary evidence in his possession, which may throw some light to the controversy. If it is a document which is not his statement, now my lord, I will stress on this. If it is a document which is not his statement, conveying his personal knowledge relating to the charge against him, he may be called upon by the court to produce that document in accordance with the provision of Section 139 of the Evidence Act, which in terms provides that a person may be summoned to produce a document in his possession or power, and that he does not become a witness by the mere fact that he has produced it, and therefore he cannot be cross-examined. Of course, he can be cross-examined. Of course, he can be cross-examined if he is called as a witness who has made statements conveying his personal knowledge. Now, my lord, by reference to the contents of the document, or if he has given the statement in court otherwise than by reference to the contents of the document. Now, my lord, here the testimonial part which the court is discussing, if a document is produced wherein his personal knowledge from facts are being conveyed, then it is stated that 20 sub-article 3 will be invoked. Now, my lord, next paragraph, very important, my lord. It is well in the same paragraph after a line, my lord. It is well established that clause 3 of Article 20 is directed against self-incrimination by an accused person. Self-incrimination must mean conveying information based upon the personal knowledge of a person giving the information, and cannot include merely the mechanical process of producing documents in courts, which may throw a light on any of the points in controversy, but which do not contain any statement of the accused based on his personal knowledge. For example, now, the accused person may be in possession of a document which is in his writing, or which contains his signature or his thumb impression. The production of such a document with a view to comparison of the writing or the signature or the impression is not the statement of an accused person, which can be said to be in the nature of a personal testimony. Now, my lord, in this situation now, when an accused is called upon by the court or any other authority holding an investigation to give his finger impression or signature or a specimen of his handwriting, he is not giving any testimony of the nature of a personal testimony. The giving of a personal testimony must depend upon his volition. He can make any kind of statement or may refuse to make any statement, but his finger impressions or his handwriting, in spite of efforts at concealing the true nature of it, by dissimulation cannot change their intrinsic character. Now, my lord, here the document which is sought for by the court, if it is produced, it will not change it falls within the same category, my lord. It will not change. I will repeat this line, my lord. Cannot change their intrinsic character. The document would remain the same. Those document is not the statement of the accused wherein an indication has been brought forward that he is being incriminated in such material. Now, my lord, thereafter it is stated, when an accused, the giving of finger impression or of specimen writing or of signature by an accused person, though it may amount to furnishing evidence, in the larger sense, it is not included within the expression to be a witness. Thereafter, my lord, in order that a testimony by an accused person may be said to have been self-incriminatory, the compulsion of which comes within the prohibition of the constitutional provision, it must be of such a character that by itself, my lord, I was trying to stress on this point, it must be of such a character that by itself it should have the tendency of incriminating the accused, if not also of actually doing so. In other words, it should be a statement which makes the case against the accused person at least probable, considered by itself. If that document, when placed before a court and the court comes to an opinion that yes, this is proving my case against him by looking at that document itself, then it will be incriminating.
So you are adopting the argument of Dr. Chaudhary.
But I'm not adopting the
Your contention is that the document exhibit 7 series are forged.
Yes.
So it is your contention that those documents are incriminating against him, and you are asking for production of those documents,
my lord, this is
which prove it may go against him. It may be found incriminating against him.
My lord, when it is produced, per se produced, it will not incriminate him, my lord.
No, sir. Mr. Singhal, look to this. In order that a testimony by an accused may be said to have been self-incriminatory, the compulsion of which comes within the provision of the constitutional provision, it must be of such a character that by itself it should have the tendency of incriminating the accused, if not also of actually doing so. Let us take a point. I'm exactly on that. I'm reading once again, Mr. Singhal.
Yes, sir.
In order that a testimony by an accused person may be said to have been self-incriminating, the compulsion of which comes within the provision of the constitutional provision, it must be of such a character that by itself it should have the tendency of incriminating the accused, if not also of actually doing so. In other words, it should be a statement which makes it be that as what I am on, Mr. Singhal, please explain that according to you, Exhibit 7 series are forged documents.
Yes.
If your contention stands, it becomes incriminating to the accused.
Not that way, my lord. This is not that what Supreme Court has held. It is said, if the document is
The
seen,
Supreme Court has passed this judgment with regard to the
5 facts.
With regard to the constitutional, with regard to the decision of the learned trial court to give specific signature
Signature.
in the light of the provisions of the Article 20 within bracket Article 20 clause 3 of the Constitution of India. This judgment is on the basis of that. But my specific question, I'm exactly on that question, that when you say that these documents are forged and you want production of that document through the order of the court, and if it is proved that it is really forged, so does it not hit Article
No,
20
my lord,
within
that
bracket
is
3?
not the case. My lord, there are 4 factors has to be fulfilled.
Please be prepared with your reply. Please be prepared with your reply. After recess, I will hear. This will continue. And one thing I like to show you once. Because some parashana we also do in our home. So I like to draw one attention. Please come to paragraph number 32 of the AIR 1965 Supreme Court.
1965.
His judgment. Keep. Have you seen? There is one other consideration which is important. Article 20, clause 3 has been construed by this court in Kalu Ogad. This one. To mean that an accused cannot be compelled to disclose documents which are incriminating and based on his knowledge. Please reply on that.
My lord, may I make?
On the last occasion, which is why I asked you.
My lord, I
whether-
have to make.
I mean, you will give the reply
My lord,
after recess.
My kindly takes my humble submission, my lord. Kindly takes it up tomorrow. Top of the list, my lord.
No, it will be taken up at recess. Ashun. After recess.
In light of Article 23.
On the last occasion, I've indicated, I've asked him a question, whether while passing this judgment, the Honorable Supreme Court has considered this judgment or no. No reply came from my bar.
No, my lord,
I
this
took
is a
it home
subsequent judgment.
And I found that there was a reflection.
Yes.
Lordship, may I be permitted to mention, Lordship?
Yes, Mr. Singhal. You don't need to read each and every line.
No, I'm
already
not
gone
reading
through.
each and every line, my lord. I'm just with the query of the
Time is precious.
Yes, sir.
Of course, without prejudice to the interest of your client.
My lord, now, my lord, I was trying to place that the documents which are in question here, I am challenging it. I'm saying it is not a valid document. They are saying they have produced it before a court, claiming it to be a valid document. Before a court of law, they have exhibited the same voluntarily. Now, my lord, this one factor is very important to be considered. The person who has produced this document in the first instance has already produced this document in a first instance before a court of law.
That submission is
Voluntary.
made, sir. That submission you have made on the
Yes,
earlier
my lord.
occasion.
I'm just connecting dots, my lord. Now, my lord, subsequently, my lord. Huh?
Please take your seat. Please be remained silent.
What I am saying is the document that were exhibited was not my document, it was exhibited by the petitioner. In his possession, having an original document before a court of law, seeking a right. Now, my lord, here, when that document is being called for by a criminal court, looking into and inquiring into the matters, wanted to throw a light in the controversy because the entire case revolves around this particular document which the petitioner has produced before a court of law in an evidence. Now, my lord, kindly takes para 12 that we, my lords, were considering before that. My lord, here, my lord, because these sets of judgment has been dealt by the Honorable Supreme Court in light of the facts that there were 5 kind of instances wherein the court was to be considered. This fact that the present situation that has arisen is distinguished in those particular facts, but there are some similarities to it. That's what I seek to bring before this court. Now, a handwriting or a fingerprint impression. Now, the court has said that it will not be incriminating because it has to be compared with some other thing, and thereafter a conclusion will come. Here itself, the court says when the document itself, when produced before a court of law, now it is not whether what I am contending or what the petitioner is contending. The court has to see that document independently, whether on perusal barely of that document, whether any incriminating materials, whether it is self-incriminating the accused, just mere production of the document. That is no, my lord. My lord, that is my argument's sake and what the Supreme Court has said. That is not self-incriminating here. Self-incriminating would be when the document on perusal itself reveals that an offense has been committed that is being tried by the accused. That is when the accused will be self-incriminating himself. But mere looking into a rent receipts issued by a other person with other person's signature, how the accused will be self-incriminated in it. It will only be considered by the court to see whether the document here is incriminating or not. That is what para 12 is saying, my lord. A specimen handwriting or signature or finger impression by themselves are not testimony at all, being wholly innocuous because they are unchangeable except in rare cases. Now, my lord, if 12, yeah, no. 61, 1961. Article law. Yeah. Para 12. The nature of the handwriting, if it's taken from the accused, it will not change. It will remain the same. Same way, my lord, the rent receipts it is produced, it will not change. It will remain in the same character as it is. That is what court is saying. A specimen handwriting or signature or finger impression by themselves are not testimony at all, being wholly innocuous because they are unchangeable except in rare cases where the ridges of the fingers or the style of writing have been tampered with. There are only materials for comparison in order to lend assurance to the court that its inference based on other piece of evidence is reliable. They are neither oral nor documentary evidence, but belong to the third category of material evidence, which is outside the limit of testimony. Well, these documents, even the rent receipt is not the testimony of the accused. It is a document which shows that a rent of a particular property is being paid by some person. It is not the saying that I am a forged document or this document is forged. That document is not speaking at itself.
It's a material.
It is a material. And the court has to look into material evidence whenever it is inquiring into an offense of such serious nature, my lord. Now, two factors which are very important here, my lord. It was that this document was in possession and has been relied upon by the petitioner before a court of law voluntarily. He was never compelled by anyone to produce this document. He was exhausting his right, trying to.
Forget about that.
Yes.
For the timing, according to you, those documents, the exhibit 7 says, the rent receipts, alleged rent receipts are barely materials, not evidence.
Those are material evidence, my lord.
Those are evidence.
Yes. Those are documents which are of material evidence, my lord. But that document on perusal on itself is not incriminating anybody. This is what the court is saying to.
Mr. Singhal, I'm not clear on that point. In the complaint case, for the sake of argument, this court affords the order of the trial court, and in the event the accused produces those documents, those are only materials or material evidence. Mere on production, that I intend to do.
It is a relevant material, my lord.
So those are not evidence. For the purpose of the complaint case, those are not material evidence.
But that is the cause of action from where the everything arose.
It will be used as an evidence or not, that will be decided later on. But mere production is not an evidence.
My lord, it is not incriminating evidence. That
What
word is important.
against you. Try to understand what I'm asking. Those documents are evidence or materials only?
Materials.
Not evidence.
Not yet.
Otherwise, it will attract to 23.
My lord,
Is it your argument?
No, my lord, it will not attract 23. This is my argument. These documents.
Just signal, they are probably, and I'm not, I cannot make you understand. For the sake of argument, if I afford the order of the trial court, and if I direct the accused to produce those exhibits, those production of the rent receipts, alleged fake rent receipts, are materials or material evidence, according to you.
It's material, my lord.
It's material, absolutely.
I have to prove that.
If it be material evidence, then it will be attracted under Article 23. But if it is material, it is your argument that it will not attract under Section 20, subsection 3.
My lord,
Because
in this
91 says that mere production does not say that he will become a witness.
Yes.
That you want to say.
My lord, I am trying to say this mere production, the court cannot infer whether it is incriminating or not. If it is produced before a court to throw some light, that document itself is not incriminating. My lord, that's what we were.
Exactly, Mr. Singhal, I am with you.
Yes.
Then, sir, read once again. They are only materials. Read from there. Sir, each line has relevance.
Yes, my lord.
They are only materials.
They are only materials for comparison.
They are only materials as argued by you,
Yes.
Mr. Singhal.
Yes, my lord.
Now come to the next point. They are only materials
For comparison in order to lend assurance to the court that its inference based on other pieces of evidence is reliable.
Then question arises. Again question arises. Those materials are placed. The court will send those to the handwriting expert CFSL with the specimen or admitted signatures. Am I correct?
Not sure.
In order to get an report from the CFSL with regard to the genuineness of this document. Again, that question arises. Where are those admitted documents?
My lord,
Where are those admitted documents? Where are the specimen documents on the basis of which comparison would be made? Because on the basis of the comparison, the handwriting expert will prepare a report. That report he will has to come before the trial court and to prove in accordance with law. Then it will be admitted in evidence. That report will be admitted in evidence. Where are those? Again, question, same question.
my lord, those questions, my lord, I had even sought for some clarification. My lord, it has been informed that when the complaint case was filed, along with that, my lord, the documents which were exhibited by the Mr. Bansidhar Agarwal in his suit in 1997, those were also placed before the court, my lord, along with the complaint case.
So according to learned trial court, and this court will act upon anticipation.
No, my lord, the court is having those documents in its records.
In the complaint case?
Yes, my lord.
In complaint case?
Yes, my lord.
Admitted documents are there?
My lord, the suit that was filed by the deceased,
Oh.
there bears the signature.
So you are putting the cart before the horse.
My lord, this application was the real intent.
Premature.
My lord,
Then
if
this application is
for-
premature.
my lord, at the very
yourself is
initiation,
admitting yourself is admitting that those admitted documents or specimen documents are not there.
my lord, it is there. And that is what I am placing with the
Before the
complaint.
trial court.
Before
In the complaint case.
in the complaint.
Show
case.
me. Show me that admitted and specimen
My
documents
lord,
are
that is
there.
not reflected in the orders. That I am not able to place. My lord, now what the court has passed is,
Have you indicated
my lord,
in your application? Have you indicated in your application that you have filed admitted or specimen signature of such and such?
my lord, I have
No
stated
pleading.
that there are admitted signatures.
No pleadings are there. Very good. Any more? Anything more? I've understood your argument. Anything more?
My lord, I will sum up my argument in this case. My lord, first of all, the documents which are sought for is non-testimonial. It's not the testimony of the accused. The accused has produced that document voluntarily. These documents, even when produced again, is not self-incriminatory. In the sense, because even if it is produced, it won't change his intrinsic character. It would remain the same rent receipts that has been submitted. Now, if I compare it with, court compares it with, is completely different fact, my lord. Now, my lord, I have in possession of the certified copy of the said document that were filed by them before the court. My lord, right now, the court has called for this document and has not directed for examination or sending it for forensic examination, my lord. My lord, if it is not produced today and it is not kept with the record of the court, my lord, there might be further tampering of the documents. My lord, they will try to frustrate the entire process.
Take down. Hearing is concluded, judgment is reserved.
My lord, for this,
Replies required.
my lord, in that case, my lord, first case, second case, my lord, there is a very inordinate question I want to just point out, my lord. Kindly looks into the prayer of the second
Yes.
application, my lord. It cannot be granted, my lord. Both the application are seeking the setting aside of the order passed in CR case number 23 of 2019. And while the second case is not with relation to CR case number 23 of 2019, that doesn't matter.
At the same time, case numbers are different 4 of 2020.
Well, that has
I've noticed.
And my lord, second thing, my lord, I want to point out very fairly, my lord, This was second application is an application under section 340. My lord, there has been some error on the part of the learned trial court.
Huh. There is not a complaint case.
It is not a complaint. It was an application under 340, my lord. The court has taken cognizance and thereafter sent it for trial. The
Arising out of the self-same cause of action.
my lord, 340 application filed
340 application was filed by before whom?
before the learned civil judge senior division at Kalimpong, my lord, wherein they had produced the forged rent receipts.
And that case was treated as a complaint case.
That was sent for trial, my lord, after taking.
Huh? So that case was treated as a complaint case.
My lord.
CR case number 4 of 2020.
My lord, what section 340
On the basis
says
of
it?
a 340 application.
Yes, my lord. This is completely
So on the self-same cause of action.
my lord, but these have different punishments involved, my lord. One is under section 340 for submitting false evidence before a court.
So in this CR case number 4 of 2020, the learned trial court, that is the learned James Kalimpong, has to come to a finding that those documents are forged.
Yes.
And here also the court has to come to a finding. Understand your case.
But only one thing. But,
No replies required.
this is one more judgment of the Honorable High Court of Telangana. Same issue decided by the High Court saying that. But
Was there exhibited documents in facts?
দেখি দাও ওটা দাও কি বলছে না দেখি নোট করে দাও নোট করে দাও নোট
I'm asking, that's what
I'll tell you. Wait.
Give me the citation
Wait,
or
wait.
something.
But it's 2021 SCC online. We'll see. This is your copy. Wait. 2021 SCC online. TS 1406. But I will receive two paragraphs only.
Yes, paragraph.
Paragraph 9. But the High Court had considered.
Para 8 and 9.
Para 8 and 9. The High Court has considered all these judgments and thereafter, comes to finding that in Choksi, but the 1965 judgment I have relied upon. But in that judgment, exactly the point was whether 91 is applicable to the accused or not. But in the other judgments,
Please.
Para 8, the combined High Court of Andhra Pradesh in Hemlata versus so and so held that section 91 of CRPC cannot be invoked against the person accused of an offence. And state section does not apply to the accused persons. And that the court and police officer is not having power to call for impunity measures from an accused. In view of the above authoritative pronouncements, coming to the facts of the case at hand, admittedly the petitioner herein accused in crime number so and so registered for the offence so and so. Respondent number 4, investigating officer directed the petitioner herein to produce the aforesaid information from him with a impugned notice under section 91 CRPC. Said information document sought by the investigating officer is from the possession of the petitioner accused number 1, and the same is incriminating material which the investigating officer cannot call for from the petitioner accused number 1 under section 91 of CRPC. Therefore, the impugned notice is illegal and the action of the respondent number 4 in calling the same information which is incriminating material from the possession of the accused number 1 under section 91 CRPC is illegal, violative of the principle laid down in the aforesaid judgment and against the protection guaranteed under Article 23 of the Constitution of India. Further, respondent number 4 has no power to direct the petitioner accused number 1 to produce the incriminating material from his possession.
Nothing new has been decided, sir.
Lord,
Mr. Chaudhary,
not new.
if any new is given, don't pardon me with unnecessary judgment.
Just placing this before your lordship only to impress that same issue was raised before the Andhra Pradesh High Court. The Andhra Pradesh High Court has categorically held that in Choksi the issue was very categorically was that 91 is applicable to accused or not. Katikalu Ugat was also relied upon here. Katikalu Ugat is also taken into consideration in Choksi. So, my lord, the court says since Choksi is on the issue of 91, the court draws the analogy from Choksi and holds that 91 is not applicable.
Right.
But I will just place it, I will just say the paragraph. That's all.
It is also Telangana High Court.
Telangana. Para 19. Para 19, para 21, para 22, and para 23. That's all.
Relying upon those two giants. Very good, chal. Katiogat Kalu and Choksi.
Yes.
Sure.
Lord. It's a pleasure, my lord, to argue this matter before your lordship, my lord, because since your lordship gives a patience hearing on everything, my lord, that is the most important thing for a council, my lord, irrespective of the outcome. Faith of the case.
Really, very happy. From principal pay, every 5 feet. Really,
Grateful, grateful, my lord. Grateful, my lord. And thank you.
I'm learning every day.
Yes, my lord. Grateful, obliged, my lord.
Call the next matter.
Item number 4.
4 কেন আবার 4 কি হলো? ও কি আছে এটা? কেন এটা এলো কেন? মিস্টার ভেদ রায়, where is Mr. ভেদ রায়? উনি এর সাথে ইনার জুনিয়র তো মিস্টার ঘোষের। কি মামলাটা হয়ে গেছে? বুঝতে পারছি না। এটা কেন মেনশনিং স্লিপটা কোথায় বলেন বাবু? মেনশনিং স্লিপটা কোথায়? Application. Can one not dispose of? ওইটা বোধহয় অ্যাডমিশনই হয়নি নাকি? The appellant is not represented. Stop para. Let the matter go out. Yes, call the next matter. কি হলো ঠাকুর? Basu. हमला करा सर काउকে পাওয়া যায় না। The parties are not represented. Full stop. The department reports the trial court record has not yet been received. Stop there. In view of such, learned judge, MSc Tribunal, FTC second, Jalpaiguri, is once again request.
I know. And there are the appeal, 56. I know that there are the direction in the previous day. Submit postal process, I have submit this.
কোনো রিপোর্ট আসেনি?
I know. Of the completed process. But time
18/8. Today is 19. Yesterday you have deposited.
not completed all the process.
No. Order was passed on 24th July.
And then, permit not completed.
Bojo.
I will finally keep this.
Why you people have mentioned that MSCC cases are not taken up? Kindly take up the matter. No. When the last coordinate bench passed an order for deposit of cost on 24/7/2025, what makes you to deposit on 18th August, yesterday?
My lord, previous occasion, I meet several time in the department, but process not ready.
Have you taken up with the matter with the registrar?
My lord.
Show me your correspondence. Have you taken up the matter with the learned registrar in writing that there was a direction of a coordinate bench dated 24/7/2025 for deposit of the postal cost, but the department is not accepting? Have you made any complaint? Then
I went several times, but department stated that not ready.
what is not ready?
The process.
Registrar sir will take up the matter with the department if you made a complaint.
My lord, my class.
More muskil. What is your name? It's Mr. Das. Mr. Das, learned advocate for the appellant, says that he has deposited the postal cost on 18/8/2025. Stop.
Lordship, 5750 counter appeal counter. Lordship, Showmallo, Mr. Showmallo is appearing on behalf of the insurance company. He is from Calcutta, he is appear partially. He just give me a WhatsApp message, I will take a short also.
Let the matter be listed before the next available circuit bench.
Lordship, it will be taken up just sometimes after.
Sorry. You people are not interested. Why?
Lordship,
Why the court will?
Why are the Lordship?
No, sir, I am not.
Actually, he is.
Very good. Call the next matter.
If insurance is not appear, I shall what I can do. Lordship,
You need not do it. Have I passed any adverse order?
Lordship, he's following.
Have I passed any adverse order?
No, Lordship, actually, I beg to.
Sir, I have come to an impression that you people don't made a complaint at the first on the very first day of the circuit that our MSCC matters are not taken up. And when I have decided to take up the matter, you are seeking patronment, this, that. No, sir.
Lordship, last 5 circuits, no hearing of the appeal has been taken. That was my say.
And when this court is interested to take up the matter, you are not cooperating.
Please, Lordship, take up. Please give the password.
Ask your friend to appear before the next available circuit bench.
Lordship,
All the next matter. Who is appearing?
Lordship, in this matter, I am appearing with Mr. Abhijit Raha. Mr. Raha is present in the court. You will file the paper book, Your Lordship.
Who is
You
the
have
other
served
side?
the copy. This is my appeal for enhancement of the award, Your Lordship. The victim was the mother of the appellant.
Give me a second, sir. Yes, sir.
Lordship, the victim, the mother of the appellant died on 19th March 2018, Your Lordship. Now, at the time of the accident, Your Lordship, he was a tutor by occupation, but the London Tribunal assessed the income after treating the victim as the homemaker. Now, London Tribunal assessed the income 5,000. We claimed rupees 6,000 since Your Lordship it is 2018. Now, in 2018, Your Lordship would assess the income as 6,000. This is the first point. And the
Give
other
me a,
point, Your
wait,
Lordship,
wait. Give me a second.
first point is the income, Your Lordship.
Huh. Who has
It
died?
was assessed at rupees
Who has
5,000.
died?
2018, 19th March 2018.
Mother has died.
Mother has died.
Claimant is the son.
He was aged about 47 years at the time of the death.
What was her avocation?
Avocation, she was a private tutor, but the London Tribunal accepted that she was homemaker. That was page 32, Your Lordship, of the paper book.
Page?
Page 32. Page 32.
Yes.
The second para, Your Lordship, applying the apostate principle after applying Urun Agarwal.
Hmm.
The London Tribunal assessed rupees 5,000 per month. Since Your Lordship, it is accident in 2018, Your Lordship, that could be assessed as 6,000, Your Lordship, per month.
Yes. Next.
Next point, Your Lordship, the future prospect ought to have been granted. No future prospect has been given, Your Lordship. Since she was 47, the future prospect should be 25% at that time, Your Lordship. The future prospect ought to have been assessed at 25% of the assessed income.
Where the future prospect has been described, discussed?
That was not discussed at all. That was not discussed at all.
So if it is discussed and if it is assessed in an appropriate manner, what would be the effect?
25%, Your Lordship. 47 years age. According to Pune State, Your Lordship, 25%. Age, Your Lordship, age was proved as per Aadhaar card and PM report, Your Lordship.
Huh.
Age was proved, Your Lordship.
It
Age
should be, it should
47.
be, it should be 60,000 into how much?
Your Lordship, Your Lordship,
Then it should be how much?
6,000, you said
6,000 into
25%,
12.
1,500.
Huh?
6,000, 25% is 1,500.
Very good. 6,000 is 25%.
So 1,500.
Yes.
And then, Your Lordship, the general damage that was given 30,000.
No,
But Your Lordship,
1,500 is to added with hood. What?
with 6,000. 6,000 is the monthly income. Future prospect is 1,500. So it should be 7,500. Monthly income was assessed as 5,000. Your Lordship. My first point, Your Lordship, it should be 6,000.
I understand. What about the future prospect?
Future prospect. According to
future
the
prospect
age
is,
of the victim, 25% would be future prospect.
then it comes to 1,500.
1,500.
Huh.
So your lordship, it should be added with 6,000, so 7,500.
Then it should be multiplied by 12.
Multiply 13, your lordship. According to 47, your lordship, Salla Verma multiply 13.
Why 13?
Multiplier is, according to Salla Verma, it is 13, your lordship.
No, annual income.
Annual income, your lordship, the multiplier would be 13. According to schedule, your lordship, as per judgment of Salla Verma, my junior will hand it over the judgment of Salla
No,
Verma.
no. If your contention is that our monthly income is 6,000 and
Your lordship.
future prospect is rupees 1,500 per month, and the
Then
total income comes to rupees 7,500 per month.
7,500.
Then what is their annual income?
Annual income was 6,000, your lordship. Future prospect 1,500.
My lord, I can give the assessment
কি দিচ্ছেন দাও আমাকে বুঝতে
calculation.
annual income rupees 6,000. Annual income Brahmatu. Is this annual income or monthly income?
This is monthly, your lordship. Sorry, I
Correct,
beg to
correct,
pardon, your lordship.
correct.
Monthly income. Annual income, your lordship, 6,012, 72,000. Monthly income. I beg to pardon. Monthly income would be 7,500 with future prospect. Then we multiply by
Monthly income is 12 is 72. Deduction 1/3 24,000. Future prospect 25%. Age 47 years. 12,000. It comes to what is the basis of future prospect, sir?
features of the Ponashetty, your lordship. Ponashetty judgment.
If there have you got any judgment?
Start with the Roman code.
Mark code, mark code. What is the pronunciatory judgment?
Your lordship.
Huh. Which
According to
paragraph relevant?
was self-employed.
Last page of the paradigm, Roman 4.
Your lordship, kindly come to para 61 of the judgment, your lordship.
Huh.
Para 61, your lordship, clause 4. Clause 4. In case of this is self-employed on a fixed salary, an addition of 40% to the established income where the disease was below age 40 years, an addition of 25% where the disease was between 40 to 50 years. Here disease was 47 years. So 25% would be the future prospect.
So how you have proved that you are a self-employed?
Your lordship, we said that the disease was a private tutor, but a learned tribunal assessed the income as she was homemaker. So after giving the service to the family. And the Supreme Court says in all the matter, the future prospect should be added. Whether notional income or any other income. And your lordship already delivered a judgment, your lordship, yesterday.
Huh.
In that
Adding
matter
future
also, your
prospect.
lordship.
In your case, I added future prospect.
Baldev order, Your Lordship, added future prospect.
That judgment is here. Give it to me. এই কত অ্যাড করেছি ওখানে ওটা আমারই জাজমেন্ট দিয়ে দিন
Number 24.
Learned trial court has not added future prospect.
No, Your Lordship, did not.
Very good. Then
Then, Your Lordship, the general damage, London Tribunal granted 30,000. Your Lordship, in Madhuvidas, Your Lordship granted 40,000 as consortium, Your Lordship, after following Nanuram, Your Lordship. Magma versus Nanuram. So that amount should be given, Your Lordship. Your Lordship judgment, Your Lordship, delivered on 14th August in Madhavidas.
loss of
Madhavidas?
consortium was not considered.
No, only 30,000 funeral expense and rub and affection was granted. 30,000 was granted. Another 40,000 was not given.
Funeral
That filial consortium, Your Lordship.
loss of love and affection means that comes under
Loss-
which
Loss of that should be
consortium?
loss of state.
Loss of
That
estate.
should be loss of estate. So it should be 70,000 total, Your Lordship. And that would be added by 25%, Your Lordship, since 10% would be increased in every 3 years. So judgment delivered in Pune City in 2017, it is 2025. So it should be added with 14,000 extra, Your Lordship. So 84,000.
Then
And Your Lordship, the interest. The London Tribunal granted default interest. The Lordship knows that the mandatory interest should be given on the awarded amount. So I am paying Your Lordship interest on the enhanced amount and the interest already granted on the amount of rupees 5 lakh 20, Your Lordship. So interest, Your Lordship, on the two parts. Since default interest was granted, the mandatory interest should be given on the already awarded amount. That is 5,50,000 from the date of the filing of the claim application till actual payment made before the tribunal. And 6% on the enhanced amount from date of filing till actual payment.
so as per your calculation, the amount of compensation comes to rupees 8,64,000.
Your Lordship. 5
Which
lakh
will
50
carry,
granted.
which will carry interest at the rate of 6% from the date of making the application.
Your Lordship.
And that will be, and that total amount will be deducted from the amount which you have received towards
Your Lordship.
compensation as well as interest.
Your Lordship.
This
Your
is your
Lordship.
contention.
Your Lordship.
So let me sum up your argument. Your first contention is that the deceased was the mother of the claimant who died at 47 years.
Your Lordship.
Your submission is that assessment to the tune of rupees 5,000 per month is low. It should be rupees 6,000.
6,000.
Learned trial court has failed to consider the future prospect.
Your Lordship.
Tune of rupees 25,000 on rupees 760,000.
Your Lordship.
And you have also submitted that learned trial court has not granted any sum towards the loss of consortium.
Your Lordship.
And learned trial court has also failed to grant 20% on enhancement on general damages.
On general damage.
And your last submission is that the learned trial court has granted default interest, which should be
Mandatory.
from the date of the
Filing of the claim.
submission of the application at the prevailing bank interest, that is at the rate of 6%.
Your Lordship.
So your claim, your prayer for enhancement of compensation on the basis of the calculation as per your submission,
Your Lordship.
direction to the insurance company to pay
pay
the
the-
money
With
less
interest.
the amount which has been received by the
Your
claimant
Lordship. Your Lordship. Your Lordship.
towards the compensation and interest.
Your Lordship.
Am I clear?
These are my points, Your Lordship. Deep love, Your Lordship.
Not applicable to the function. That's why the court is not granted any reserve function. And since we have already paid the 5,50,000 lodging, so there is no interest calculating that amount of project subsequent enhancement. We have no objection, but regarding 5,000, we have objection. Because we have already paid as per the relation of the full year. So I have to copy.
Take down. The informal paper book as filed on behalf of the claimant appellant Hmm? That's all.
Any problems, Your Lordship?
Call the next matter.
But I think they appear on the appellate. But in this matter, another case has been filed from the side of the interest company. So my submission would be, my lord, both the appeals may be heard together, my lord. I just come to know that another cross appeal has been filed from the side of the insurance. Number is not 55 of the 2023. FMAT MV, FMAT MV 55 of the 2023.
There is a process. In last week, both the people running only the parents of it are getting watched.
Worship, that file is also here. That I have asked, actually,
Good.
it is mistake on part of the
Hmm?
preparation of this. But both the files is there, the appeal can be hard to get. Lordship, please. What offense I did, Lordship, I can't understand. Lordship, please. Lordship, please. Lordship, please. It is not our fault on my part, Lordship. On Thursday, it was in the list. Both the matter was in the list. Lordship, day after tomorrow, only 2 appeals lying. That another is also mine. Day after tomorrow, only 1 appeal will stay. Yes, Lordship.
There is another company, the name of the other vehicle was appearing not. We have no role inside of that for
Other vehicle. Yes, 50-50. I have also served, but they are not appearing. They are not contesting. Even in the before tribunal, they have not contested. They filed, they appeared, they filed, but in last time they no written statement, but nothing affected. Loss is affected, and everybody of service I have filed. ওনাকে ওকে না এনগেজ করলে উনি কি করে আসবেন in spite of having receiving at least $50% direction has given. Oriental already paid 50% amount in before tribunal, Lordship. Lordship, we have served, but they are not appearing in spite of having the notice. They are not appearing. Of Oriental Insurance Company. I will enquire the matter fixed in the next circuit. I will arrange all the matters. Yes, I am. কষ্ট করে রেডি করবো কষ্ট করে একটা হিয়ারিং আসবে তারপরে আলটিমেটলি নেক্সট সার্কিট হয়ে যাবে they have already paid 50% of the
কিছু আছে?
Number 62. Worship, I have heard that.
Is ready? Is ready? Is it ready, sir?
Worship, yes, worship. Worship, I have a short most of our. Worship, you do the.
Who is for the insurance company? You are agreed with the quantum. Why?
Worship, monthly income of that is wrongly assessed by the learned tribunal at the rate 26,156 per month instead of 30,000. Less professional tax 150 equal to that would be 30,150. That would be 30,300. It is wrongly typed. Amount would be 3,030. Lordship kindly, his income and kindly see exhibit 9, page 56 of paper.
পেপার কোথায় কি আছে? এই পেপার বুক কোথায়? Page number?
Lordship 56, last page, Lordship. Here is the service book of late Om Prakash Prasad and that is service for the 6 months. She last page on rupees 30,300.
Absolutely illegible.
Lordship, record is LCR is here. We have got the I copied from certificate copy.
কই দেখি এলসিআরটা দেখি বাবা কি আছে?
Exhibit 9 of Lordship last page.
Yes.
Last page of the exhibit 9, Lordship.
হ্যাঁ।
Everything is gone. This is separate here. This is not finally. This is the exhibit together, all together, and that can be seen from the later. Lordship kindly see page 48. What they have given in exhibit 9, the department. Let me argue. Now, this is not different thing. Lordship kindly see the.
Where is your pay statement?
Lordship, that is also
Basic
eligible
pay,
in my
DA,
in my
HRA and GP.
all have been taken separately. And I could not find the sum up. I find the sum up in that letter.
In returning here with a service for interested, his qualifying income has been put for up to with last drawn payout of 30,300. 30,300.
See,
Huh.
Lordship, Lanet Tribunal put that amount 26,156.
Why?
I think from any place of service book that has been written, and that is overlooked by the Lanet Tribunal, that last pay was this 30,300. Lordship, another thing.
Wait, sir, wait. Are you in a hurry?
No, I have, this is the only point of appeal, Lordship.
মুশকিল হলো
I am interested.
এই কল্যাণ বাবু পকেট থেকে মোবাইলটা বার করুন, মোবাইলটা বার করুন, ক্যালকুলেটর করুন। বলছি এক সেকেন্ড। The 9840 plus 1111,740 plus 9840 plus 11,11740. 9840 plus 11740 plus 1761 plus 1900 কত হচ্ছে? 25,241।
Should may I, you should, I will calculation in the next stage. May giving also one.
এটা কত করবেন? 26,116, এটা কোনটার সঙ্গে অ্যাড হলো? আচ্ছা এইটা 25,241 তো, 26,156 মাইনাস 25,241, আমার চাকা কত ছাড় 915 টাকা থেকে ছাড় 915 টাকাটা কিভাবে আসছে? ওই 900 টাকাটা অ্যাড করেছে, এই 915 টাকাটা অ্যাড করেছে। Yes.
Lordship, another point is only one point, that is
Huh?
page 27. Lordship, that is page 27 of the.
No, learned trial court actually relied upon the payslip of the October 2018. He has added the basic pay, DA, HRA, GP and IR 950. So by that way, he has come to a finding your monthly income is 26,156. But you say in returning the service bureau late, I am to state that his qualifying service has been proved 21 years, 6 months, 7 days, with loss drawn being rupees 30,300. And the following side. Very good. Then
Lordship, another is interest, so interest is given, that was default interest, at page 27. Paper. 27 of the paper. And judgment, internal page 3. Second paragraph. That was default interest at a 9% given penal interest, but no interest is given.
what have you got to say?
Okay, page number 50 of the paper.
15.
One.
Hmm.
Yeah, W3. Purpose to one something, one Vinalkan Sarkar. Staff on the soil conservation environment, he gave on being summoned by the petitioner to the income of the DC.
On the exhibit 9, which is the salary service book of the deceased, it appears that he has deposed, specifically that the deceased employee is to draw gross salary of 26,306 and not 30,000 as stated by the petitioner. And in the at page 26 of the judgment, and also at page 23, let us take page 23 first. 23 of the judgment. 23 of the paper book, page 8 of the judgment. Determination of income of the deceased at the time of the death. What is your? According to the claim application, deceased was a forest guard and he used to draw 26,306 in support of the income. Attested copy of the pay slip of the month of October was produced. It appears, they have produced the petitioner. It appears that Exhibit 9 that the gross salary was 26,306 at the time of his death. In view of the document, the tribunal finds the victim to be income to be 26,150 after deducting P-tax. That is well settled law, only income tax and professional tax will be deducted from the gross salary, gross income. So Rana Tribunal has rightly deducted rupees 150 from the salary, gross salary. That will become the net salary, and it was taken into consideration and calculated rightly. And so far interest point is concerned, it appears that no, only penal interest was given. That interest point we have no objection if the lordship allows that ground. But so far income is concerned, the income has been rightly taken on the basis of documentary evidence and on the basis of payslip addresses. And document which he is referring, it is not eligible. It is not the payslip, it is the pension which the deceased widow of the deceased is receiving. 2020 of 2020.
No, this is a letter of the AG, Principal Accountant General of the Government Employees, where from the pension papers are prepared, where says the last done pay is 30,300.
That is enhanced, it is a report or annual of revised pension.
Naturally, you can entitled to get that.
At the relevant point of time, he was getting 26,000.
Enhancement took place with effect from that date.
But at the relevant point, at the time of his demise, they have produced the file and they have filed that document, and it was further corroborated by the official departmental staff. It is also same. This is not this PPO, this is separate thing. It gets enhanced from time to time. So our submission is that income has been rightly taken into consideration for the month of.
দেখো তো একবার 2 মিনিটের জন্য নে Please spare me for 2 minutes.
May I have a glance of that PPO?
Sure. এইটাও কি লোককে দিন ভাঁজ করা রইল I'll dictate judgment.
সব বাদিয়া গুলো আমার করে নেওয়া পাবে না চলে এসেছি লোকগুলো খাবার করবে মামলা তার সব ব্যাংক ডিটেলস দিয়ে ফাইল করতে হবে
The second page of your written argument, your calculation is right. ক্যালকুলেটর দেখি ক্যালকুলেটর দিন
I also rejected professional tax conflict.
why multiplier of 9 is applied? How old is? You added general damage to the extent of 20%. আসুন
Our, to sum up, in one line, as per the exhibit, he received 26 on, and that was of October.
and he died in November, 12 November. And the pay which they are showing, that is, he has received that payment after his demise. So at the time of the death, he received the last.
No, at the time of calculating the family pension,
And that was calculated after his death.
it was calculated on
But
the basis
at
of the last drawn pay.
Last drawn was payment was made after his demise. That because he died in 12th November.
Fixation of pay has been done after his demise.
That is separate.
But it has an effect of the retrospective in nature.
That he received 1 month's rent after his demise, but at the relevant time they produced the salary of the October, because
in the event I'm telling you one thing. In the event he was alive, he was entitled to get arrear pay on account of his revision of pay.
And our submission at the time.
Give it to me.
At the time of
Oh, I'm sorry. Hey, LC din আমার.
At the time of his demise, he received 26,000.
Very good. That I've understood. I'm recording your submission. In this appeal, the judgment dated 18/11/2023. Oh, I'm sorry. Acha. The informal paper book as filed on behalf of the appellant is taken on record. Learned advocate appearing on behalf of the appellant files a short notes on argument. After serving a copy of the same to the learned advocate on record for the respondent insurance company. Full stop. The same is also taken on record.
One correction is required. One typographical mistake is there. May I correct that?
Which one?
The one figure that is 3,000. That will be 3,300.
Where?
For grounds of appeal, Roman 1 last.
Listen to my judgment thereafter. In this appeal, the judgment dated 18/11/2023 as passed in MEC case number 88 of 2019, 88 of 2019, as passed by the learned judge, MEC tribunal, 4th court Jalpaiguri is ascent. By the impugned judgment, the said tribunal, while disposing an application under section 166 of the Motor Vehicles Act 1988, hereinafter referred to as the said act in short, awarded